Hello, my name is Ana Maria Farias, HUD's Assistant Secretary for Fair Housing and Equal Opportunity. Welcome to today's Fair Housing Act training, which will include detailed explanations of the various protections the law provides. But more importantly, today's training will help you gain a clearer understanding of the continued relevance of this landmark law. Few would deny that America has made significant progress in creating equality in housing since the Fair Housing Act was passed 50 years ago. However, discrimination still exists. Each year, HUD and our many fair housing partners receive thousands of complaints from individuals and families alleging that their rights were violated. So our work isn't done. Housing discrimination is not only wrong, it's illegal. And in a country founded on the principles of justice and equality, housing discrimination is unacceptable. If America is to be the land our forefathers envisioned, then we must live by those principles. Here at HUD, it's our job to ensure that every person who calls this great nation home has the same chance to obtain housing. But we need your help. Thank you for making the commitment to learning all you can about the Fair Housing Act and how you can use this vital tool to advance fair housing. And we look forward to working with you to transform America's neighborhoods into communities of greater choice and opportunity.
Hello, everyone, and welcome to the Basics of the Fair Housing Act. My name is Christina Miller, and I'm with HUD's Office of Fair Housing and Equal Opportunity, and I will be your presenter today in our discussion about the Fair Housing Act. We're going to begin by starting at the very beginning, and that is the basics of what is fair housing and what we're talking about when we use that term. And then we're going to introduce ourselves to the law itself called the Fair Housing Act and break down the various aspects of the law to help us understand what it means, what it says, and who must comply with the law. So let's begin with what the fair housing term means. When we say fair housing, we're saying that all of us have the right to be free from discrimination in the rental, sale, or the financing of housing. So no matter what capacity of which you are watching this session webinar, whether you are an advocate, whether you are a housing provider, whether you're just a consumer, we all have the same protections under the Fair Housing Act and should expect to be treated equally. And really, that's the phrase I want everyone to take home with them after watching this session, is that when we are talking about fair housing, we're talking about equal access, equal opportunity to that housing. So you and I, if we have the same qualifications, we should expect to have the same opportunity, the same equal access to secure that housing. So I challenge you to keep that in mind as we talk about the Fair Housing Act and talk about the more difficult fair housing issues, in challenging yourselves and remembering what we're trying to accomplish when we talk about fair housing. And hopefully remembering that will help us be able to analyze specific issues and how it may apply under the Fair Housing Act. So remember, fair housing is all about equal access and equal opportunity to housing. Now, the primary federal law that regulates fair housing is the Fair Housing Act, and that is the subject of our discussion today. The Fair Housing Act prohibits discrimination both in public and private housing on what we call protected classes or bases of discrimination. And this is a critical slide to remember because this is going to help us understand when discrimination becomes illegal. So the protected classes covered under the Fair Housing Act will be race and color, national origin, religion, sex, which by that we mean gender, disability, and family status. Now, most of these are self-explanatory. When we're talking about race, we're talking about African American, Caucasian, Asian American, Native American, just some examples. Color will be the color of our skin tone. If we are darker skin tone, medium skin tone, fair skin, things of that nature. When we talk about national origin, we're talking about ethnicity or place of origin. So it could be American or Canadian or Mexican or Russian or Iraqi. Again, just some examples of what national origin would be. Then we talk about religion, things like Judaism or Islam or Catholicism. Again, just some examples when we speak to religious discrimination. When we talk about sex, as I mentioned, we're referring to gender, male and female. Now, there are various situations that may fall under sex discrimination that might not be so obvious to us. So we're going to spend some time later on in our presentation talking about different ways we could see and experience sex discrimination. So I'll just ask you to stay tuned for that. Then we have disability. And right now, I'm just going to say, for purposes of disability, we're talking about physical and mental disabilities. The Fair Housing Act equally protects individuals with physical disabilities as we do with people with mental disabilities. Now, without a doubt, no matter where you're watching from in the nation, disability is the most difficult issue under the Fair Housing Act and is the most common complaint and concern question that we will receive. So we're going to spend considerable time talking about disability and how it applies and is addressed under the Fair Housing Act. So again, stay tuned. And last but not least, we have family status. And the simplest way to think of the family status protected class is the presence of children under the age of 18 or going to have children under the age of 18, whether through pregnancy, adoption, foster care, or what have you. And this is also an area that we get a lot of questions about. So we're going to spend considerable time talking about family status as well. Okay. So these are our protected classes that are covered under the Fair Housing Act. And again, it's very important to remember these protected classes because we're going to put this information together when we talk about the issues that are covered under the Fair Housing Act. And that's what's on your screen right now. What transactions are covered under the Fair Housing Law? Well, you might guess by the title of the law, we're talking about housing, specifically real estate-related transactions. And most real estate-related transactions are going to be covered. There are some exemptions in the Fair Housing Act, and the two most common are what we call the single-family home exemption and the owner-occupied exemption. The single-family home exemption means that a housing provider who owns no more than 3 single-family homes and uses no agent to conduct any of the business would likely then be exempt from the Fair Housing Act. Okay, so they're just a mom and pop person, they own a home, they own maybe another single-family home, they do all the business themselves, then in that situation they're likely not covered under the Fair Housing Act except for those provisions related to advertising, which we're going to talk about shortly. The other exemption that we commonly see is called the owner-occupied or Mrs. Murphy exemption. And that's when an owner of a building owns this building, and it's a fourplex, triplex, or a duplex, so 4 units or less in the building, and the owner, him or herself, lives in the building itself. Then again, in that case, the building is exempt from the Fair Housing Act. It is not covered under the Fair Housing Law. Those are few and far between situations that we encounter. We most times have housing-related transactions that are covered under the Fair Housing Act, and that's what we have on our screen before us. We cover issues that involve the renting or buying of a house, an apartment, a mobile home, or even an empty lot that a home is going to be placed on. And condominiums are also covered dwellings under the Fair Housing Law. But it's not just the upfront process of securing housing. It's also the terms and conditions while you live there. So if, for example, if you are in a rental apartment complex, the terms and conditions would be in the form of rules, so that those rules should expect to be applied equally to tenants. In other words, the terms and conditions applied to the tenants should be applied equally. It's also the terms and conditions, say, of the purchase and sale agreement if you're trying to buy a home, or the contract terms in lending. Those are all terms and conditions that would be covered under the Fair Housing Act. Other real estate related transactions that would be covered are pretty much those that are going to affect a person's housing choice. That could also be anything involved in the lending process, whether it's the appraisal or the insurance or the actual lending process with a broker. We also cannot forget the importance of what we say, whether it's verbally or in writing or online. That has a powerful influence on someone's housing choice. If you tell someone they are not wanted because of their race or because they have children, that usually is going to end their housing search in your apartment or community, and now you have limited their equal access, equal opportunity to housing. So advertising is most certainly an issue covered under the Fair Housing Act. Then we have something called reasonable accommodations and modifications for persons with disabilities. This is, without a doubt, the most common area of concern and complaint that we receive in the Office of Fair Housing. So we're going to talk about this specific issue in much greater detail. But for now, it's just important to know that reasonable accommodations and modifications are issues that are covered under the Fair Housing Act. And in just a moment, I'm going to explain just a little teaser of how that issue is applicable under the Fair Housing laws. Okay. So now we have an understanding of the protected classes that are covered under the Fair Housing Act, those bases of discrimination. And now we have an idea of the types of issues, otherwise known as real estate related transactions, that will be covered under the Fair Housing Act. Well, if we put those together, it will help us understand one way that we could have illegal discrimination under the Fair Housing Act. Okay. The first thing we need to understand in this context is, what does discrimination mean? Well, in this context, discrimination means being treated differently. Okay. But not all forms of difference in treatment are going to be considered illegal. Okay. If I were to say that someone was denied housing because they smoke cigarettes, well, I think we all can agree that that person is treated differently than someone who doesn't smoke cigarettes. But is that difference in treatment going to be considered illegal? Well, hopefully those of you who are watching are shaking your head, no, that's not illegal discrimination. And the reason is that the difference in treatment has to be tied to one of those protected classes that we just talked about a moment ago. And that is why that slide is so critically important to help us understand when we encounter illegal discrimination. So for those of you that are math-minded, I used a nice simple equation, okay? Illegal discrimination is going to equal a covered issue plus a covered basis or protected class. So a simple example is, if I were denied housing because I am a woman, the covered issue is being denied housing. And that's tied to my protected class, my gender being female. And put those two together and you have illegal discrimination. So you cannot deny a qualified woman housing simply because she is a female. Okay? So a difference in treatment tied to a protected class is our first way that we can experience illegal discrimination. The second way is something that we just mentioned a moment ago, and that is if a housing provider fails to allow or provide a reasonable accommodation for a person who is disabled. Okay? And again, we're going to talk about this in much greater detail. I don't mean to sound like a broken record, but I want you to know that we're going to talk about this at length. But for now, just know that it's a matter of understanding that sometimes persons with disabilities may need the landlord to make a change or a waiver to their rules or their policies in order for that person with a disability to have equal access to housing. Okay? When we talk about reasonable accommodations and modifications, we're going to talk about in greater detail what a housing provider can do when they're encountering this type of situation. Okay? For now, we have two types of illegal discrimination: a difference in treatment tied to a protected class, and a failure to allow or provide reasonable accommodations or modifications. The third way that we could have illegal discrimination is called discriminatory effect. You might also hear disparate impact. Now, there's a lot of words on your screen right now, but basically what this is saying is that a landlord has a policy that on its face is neutral. It doesn't intend to discriminate against any particular protected class. But when that policy is put into practice, it ends up having a greater negative effect on one protected class group more than another, thereby having a discriminatory effect that could be considered illegal discrimination under the Fair Housing Act. We saw this historically in occupancy issues, where a landlord would have an overly restricted occupancy policy, and when that policy was put into practice, it ended up having a greater negative effect on families with kids. Why? Because statistically, your larger households were those with children. Now, we've seen more current issues that have a discriminatory effect that may be considered illegal discrimination under the Fair Housing Act. And toward the end of our presentation today, we're going to talk about some of those more current issues and how they could have a discriminatory effect under the Fair Housing Act. Okay? And this is what we call a theory of discrimination that will be applied to those specific issues. Okay? So at this point, what have we talked about? The protected classes and the covered issues that are covered under the Fair Housing Act. And we understand the three illegal forms of discrimination: the difference in treatment tied to a protected class, failure to provide or allow reasonable accommodations and modifications, and having a policy that ends up having a discriminatory effect on a protected class group. Well, what does this mean in real terms? Okay. Well, here are some examples. It's not exhaustive, but just a snapshot of what could be considered illegal discrimination based under the Fair Housing Act. The first example is requiring a couple to move because they're going to have a child. Okay? The issue here is being denied housing. They're being told they have to move. And that is tied to the fact that they're going to have a child, which is family status. So you have an issue, you have a protected class, that means illegal discrimination. In our next example, performing criminal background checks only on African American men. So again, we have a term and condition. A housing provider has a policy of conducting criminal background checks, but they apply that policy only to persons of African American race. So terms and conditions tied to a protected class, in this case race, and that equals illegal discrimination under the Fair Housing Act. In our third scenario, we have a situation of association. So the Fair Housing Act not only protects the individual who is of the certain protected class, but it also protects anyone who associates with someone of a particular protected class. So in this third example, where a white woman is evicted after the housing provider learns that she has a boyfriend who is Mexican. So she is denied housing, which is an issue, and it's because of her association with someone of a certain national origin. And that association to that protected class covers her. And so now we have an issue and a protected class, and we have illegal discrimination. Our last example on this screen, refusing to rent to a woman because she is a victim of domestic violence. We're going to talk about domestic violence situations in greater detail, and one of the things that we'll show is that statistically women are overwhelmingly going to be the victims of domestic violence as opposed to men, the other gender in this situation. So refusing to rent to someone simply because they're a victim of domestic violence is closely tied to their gender and would be considered illegal discrimination under the Fair Housing Act. In our next screen, we have some additional examples. This first example is basically a landlord refusing to allow a reasonable accommodation, where you have someone who is hearing impaired and they need to have an alternate form of communication with the landlord. Rather than, say, on a telephone, they need to use a relay service. And a relay service, for those of you who aren't familiar with that, is calling into a central system where a relay individual has a TTY, which is similar to a typewriter, and they're able to communicate with the hearing impaired person. And then that relay individual calls and relays the information to the recipient of the call. So it is an alternate means of communicating that a housing provider should allow. So for the moment, they have to make a change in how they communicate with the individual in order for that hearing impaired person to still have equal access to that housing provider and equal opportunity to seek housing. Okay? Refusing to allow for that would be a failure to allow for reasonable accommodation and could be considered illegal discrimination under the Fair Housing Act. Now, the second example on this slide goes to something called retaliation. Okay? Individuals, all of us, have a right to file a fair housing complaint with my office, the Office of Fair Housing and Equal Opportunity, if we believe that we have been discriminated against under the Fair Housing Law. And we have the right to do that, to exercise our fair housing right without negative action taken against us. If a housing provider or any of their employees take negative action against someone simply because they filed a complaint, that could be considered a illegal discrimination under the Fair Housing Act. So the second example, refusing a tenant's maintenance request, which they would otherwise be entitled to simply because that person filed a complaint, would be considered retaliation and illegal discrimination under the Fair Housing Act. And let me just clarify that when I say file a complaint, we're referring to a fair housing complaint, because the law that we enforce and the law in which this retaliation provision is under is the Fair Housing Law. Okay? In our last example, failing to take action when a housing provider is told by a tenant that they're being harassed severely by another tenant because they are Muslim and they wear the traditional Muslim hijab. A housing provider has the responsibility to address this as a potential violation of their rules and take corrective action if they substantiate that this harassment is occurring based on this individual's religion. Failing to take any action or just simply ignoring it could be a violation of the Fair Housing Act. And it falls under the harassment provisions of the Fair Housing Act. And in fact, there are specific guidelines and standards for housing providers and for HUD in addressing harassment. And we're going to talk about that as we get closer to the end of our presentation of what these harassment standards are and how they apply under the Fair Housing Act and why this particular scenario would fall under harassment. Okay, so stay tuned for that. All right. So this is a snapshot of real-life fair housing scenarios, of real-life scenarios that could have a Fair Housing Act implication. So who of us needs to comply? Well, pretty much any person or entity who's in a position to affect housing choice. So that could be any person or entity involved in the rental or sale of a dwelling or advertisement or the sale lending process of a dwelling. Okay? But it also could be any person or entity involved in other types of real estate related transactions that's going to affect housing choice. For example, anyone involved in the lending process and the insurance process that's tied to the lending transaction. Also, our municipalities, our cities are covered in some situations under the Fair Housing Act because they zone dwellings and they provide municipal services. Let's say that the city decides that they are going to provide sidewalks to a neighborhood that is predominantly white, but refuses to do something comparable to a neighborhood that's predominantly black. And the basis for their decision is the race of the individuals in the neighborhood. That's providing municipal services in a discriminatory manner and could be illegal discrimination under the Fair Housing Act. Okay, so think broadly about those transactions that could affect your housing choice, and the persons involved in that most likely will be covered under the Fair Housing Act. Now, I didn't forget the second bullet on our screen here, and that's transactions involving design and construction. This is an area of the Fair Housing Act that could take a week or more to learn. I'm only going to mention it here, and if it's something that you're interested in greater detail, you'll want to contact your local fair housing office, and I'll be providing that contact information at the end. For our purposes right now, I just want to say that for dwellings, multifamily dwellings built after March of 1991, were supposed to be built in accordance with design and construction standards listed in the Fair Housing Act. There are 7 specific design and construction standards meant to make accessible housing for persons with physical disabilities. And if failure to meet even one of those requirements could lead any person or entity involved in the design and construction to be in non-compliance with the Fair Housing Act. So anyone involved in that process could be covered, whether it's the contractor, the builder themselves, the engineer, the architect. Any of those entities could be covered under the Fair Housing Act, depending on their role in the design and construction of multifamily dwellings. I think the takeaway from this slide is to recognize that persons or entities involved in the real estate transaction or any transaction that could affect a person's housing choice may be covered under the Fair Housing Act. So what does this mean in real life terms? Well, here again is another list of examples. Again, not all-inclusive, not meant to be an exhaustive list, but one to just give you a snapshot of the persons who could be covered under the fair housing laws. Certainly property owners, managers, and maintenance staff. They're all involved in some capacity in a person's housing choice and the terms and conditions applied therein. So for example, maintenance, excuse me for a moment, maintenance is certainly covered under the Fair Housing Law. They're involved in providing a term and condition, that is maintenance service. And because they're in tenants' units, it's very, very easy to establish a personal relationship, but it's important to remember that it's a professional one, and you need to follow policies and practices that establish equal access to those services. Okay. Other persons or entities that may be covered under the Fair Housing Law would be real estate brokers or agents, persons that are involved in renting or selling property. Also, homeowners and condominium associations, they're often forgotten about as being covered entities. And oftentimes that's because those associations are oftentimes made up of individual owners of homes or condos. But think about what those associations do. They are tasked with enforcing the CC&Rs of their community. And for those of you that don't know what CC&Rs are, basically think of the rules and regs of the property or the community itself. And they have the power to say who's going to live there and who isn't, who's going to get a fine if they don't follow the rules. So they're certainly in a power position to affect person's housing choice and housing opportunity in a condominium or homeowner community. So those associations are certainly covered under the Fair Housing Act. Other individuals that could be covered, housing authority staff, local housing authority staff provide services to provide subsidized housing to individuals, and the individuals who are responsible for administering those programs could be covered under the Fair Housing Law. As I mentioned a moment ago, builders involved in the design and construction would be covered, so the developers, the contractors, also lenders and financial institutions that are involved in the lending process of single-family homes, for example. And then again, as I mentioned earlier on, advertising. Right? We cannot forget how powerful what we say and what influence that has on individuals. So anyone involved in the placement of ads, the advertising media specifically, would be covered under the Fair Housing Law as it pertains to advertising, whether it's verbal, in writing, or online. Okay? So again, this is a snapshot of the individuals and entities who are covered under the Fair Housing Act. Okay? Again, not an all-inclusive list, but rather just a representation of who we commonly see. All right. So hopefully I've given you a solid foundation upon which we can build on in our understanding of the Fair Housing Act, where we've talked about the protected classes and the issues that are covered, the types of situations that form illegal discrimination, and actually taking real situations and applying that under the Fair Housing Act to give us a view of what might be illegal discrimination under the Fair Housing Act. Now we're going to take that foundation and we're going to build on it, build on our understanding of fair housing laws and situations and how the fair housing law would be applied. We're going to start by talking about disability issues, and then we're going to go from there and talk about gender or sex discrimination issues and how domestic violence and sexual orientation would fall under the gender discrimination provisions of the law. Then we will talk about family status and then wrap up this section on advertising. So as promised, we're going to talk about disability, okay? No matter where you are watching from, it is most likely that disability is the most common question and the most common complaint that is received. And there are several reasons for that. In my opinion, I think it's largely because it is very much an individual-based or fact-based, case-by-case situation. So what my goal here is to give you the tools to be able to analyze a situation and how the Fair Housing Act might apply and how it may implicate illegal discrimination under the Fair Housing Law. So I want you to look at this from that lens, that we're adding tools to your toolbox in understanding the Fair Housing Law. Okay. We're going to begin this discussion on disability by defining who is considered disabled under the Fair Housing Act. Who are we trying to protect? And then we're going to talk about the specific issues that we see most commonly, reasonable accommodations and modifications. And then we'll talk about the very important communication between a landlord and a person who is disabled or their advocate, okay, and the things that you can and cannot say. So let us talk about who is disabled. Now this slide, the purpose of this slide is to help us all understand who we're trying to protect under the Fair Housing laws. Okay? There are three elements that are covered under the disability provisions of the Fair Housing Act. You can meet one or the other and be considered disabled. The first is the most common, and that is someone who is actually disabled, someone who has a physical or mental impairment that substantially limits one or more major life activities. The second bullet is having a record of such an impairment, and the third is being perceived as having such an impairment. That being said, let's dive right into the common disability issues that we encounter, reasonable accommodations and reasonable modifications. Now, before we go into this, I feel it's critical that I explain to you why we have these provisions of the Fair Housing Law. Okay? So visualize for me if you can. You have a person who uses a wheelchair and they are interested in an apartment building. The only way to get inside the apartment building is by way of a set of stairs. So you have this disabled individual wheeling themselves in their wheelchair. They come to the bottom of the stairs and they cannot get any further. So they have no access to the apartment, no access to the building manager, just no access. Then you have a person who is not disabled and they're also interested in an apartment in the same building. That individual is able to walk to the top of the stairs and actually access the building. So visually, what do we have? We have the non-disabled person at the top of the stairs, and we have the disabled individual at the bottom of the stairs. Do they have the same access to have the opportunity to rent an apartment in that building? Are they on the same playing field? And hopefully everyone is shaking their head no. So the question is, how can we bring the person with the disability to the same level so that they have equal access and equal opportunity to rent the apartment? And hopefully everyone's thinking in their minds, a ramp. So in an ideal world, we build a ramp to get that individual to the top of the stairs, and now the disabled individual and the non-disabled individual are on equal playing field. They have equal access, equal opportunity. The scales are balanced. Remember when I said very early on, what is fair housing? Fair housing is about equal access. So recognizing that sometimes people with a disability come to the table at a disadvantage, there may be something the housing provider can do to provide that person equal access, equal opportunity as, say, the persons without disabilities. That is what reasonable accommodations and reasonable modifications are all about. So when we get to those difficult reasonable accommodation requests, stop, breathe, pause a moment, and remember what we're trying to accomplish. We're trying to accomplish equal access, equal opportunity to housing for everyone. Okay? So that is why we have reasonable modifications and reasonable accommodations. Well, what are they? Well, let's start with reasonable modifications. A lot of words on the screen here. Basically, we're talking about a physical or a structural change to the property with the end goal to allow a person with a disability to have equal access, equal opportunity to housing. The question often is, well, who has to pay for it? Well, under the Fair Housing Act, the cost of the physical change is at the tenant's expense. But we have a lot of folks here who administer federally funded programs, whether it's HUD apartment complexes or USDA apartment complexes. And for those of you who administer federally funded properties, it's important to know that there is an additional law that applies called Section 504. And that law raises the responsibility of our federally funded housing providers to persons with disabilities. And one way it does that is it tells our federally funded housing providers they are responsible for paying for the cost and installation of a reasonable modification, assuming that it is reasonable. And we'll define reasonableness here in a moment. Okay? We actually do have two criteria to define reasonableness, so we'll get to that shortly. Okay? Now I just want to pause for a moment and just point out that you will be seeing throughout your slides at the bottom a web page link. And if you are interested in Q&As, additional information, you can go to this particular web page and get that information. For example, on our screen right now, we're talking about reasonable modifications. The link at the bottom of your screen will take you to a very nice question and answer format guidance on reasonable modifications. So you're going to see similar things throughout the presentation for you to go and perhaps download the information if you are old school and like to have it in print, or just to bookmark the link so that you can easily access the additional information. Okay? So what are some examples of reasonable modifications? We already talked about one, and that was the ramp. Okay? Making a physical or structural change to the property by adding a ramp, which allows that individual to have equal access and equal opportunity to the housing in question. It could also be that a tenant already lives there, they become disabled, they now need a walk-in or a roll-in shower, or maybe they don't need a walk-in or roll-in, but they do need grab bars. And grab bars is a very common physical modification that we will see under reasonable modifications. So these are some examples of modifications that you might encounter for persons with disabilities. The next issue that we commonly see is reasonable accommodations, and it's similar to modifications in that it is a change. But in this case, it's a change, a waiver to policies, rules, practices, or services of the housing provider. So again, it's a change, but in this case, it's a change to how we conduct business. And again, though, the end result, the goal, is to afford that individual with a disability to have equal access, equal opportunity to housing. Okay? Both the dwelling units and the common and public use areas. Okay? Again, I can't stress enough, the end goal here, the end game, is to provide equal access, equal opportunity to housing. So what are some common examples? Let's say parking. Let's say that you have parking available, but you don't allow reserved parking. Well, suppose someone with a physical disability cannot walk more than 200 feet from point A to point B, so they ask for a specific parking space that is maybe 150 feet from their unit, and they ask the housing provider to reserve it. Okay, that may be an accommodation. For that moment, the housing provider makes a change to their no reserved parking policy in order to afford that individual with a disability to have an accommodation and equal access, equal opportunity to their unit. Now remember, okay, for the term that this individual is living there, they're going to need that reserved parking. So providing them the parking isn't the end of the story. You need to make sure as a housing provider that you continually enforce that reserved parking so that that space is always available to that individual with a disability. Okay. Other examples of accommodations that we've seen are allowing caregivers on the property, allowing assistance animals. And assistance animals gets the most groans from folks, the most questions, the most concerns, the most complaints. So let me take a few moments to talk about assistance animals. You probably have heard the term service animals. You probably have heard the term companion animals. Traditionally, a service animal is one tied to an individual who needs the animal for a physical disability, and a companion animal is an animal necessary for a person with a mental disability. Remember I said under the Fair Housing Act that housing providers' obligations are the same whether the person is physically disabled or mentally disabled. So I don't necessarily like to distinguish between animals needed for physical disabilities and animals needed for mental disabilities. And that is why I use the term assistance animals, because it equally covers all animals that are necessary for persons with disabilities. And like with any other reasonable accommodation, the end goal is that that animal is necessary, their presence is necessary for that disabled individual to have equal access, equal opportunity to the dwelling and the common and public use areas. Okay? So from this point forward, I'm going to use the term assistance animal. And again, I am saying that this is an animal that is needed for either a physical disability or mental disability. We do not make a distinction between the two in terms of a housing provider's responsibility. And I'm stressing this because we unfortunately have had housing providers try to apply the Americans with Disabilities Act to dwelling units. And the Americans with Disabilities Act is much more strict about the type of animal and about training that must be provided. We, under the Fair Housing Act, do not have those same limitations. And the Americans with Disabilities Act is not going to apply to the dwellings. So please do not apply the restrictive provisions of the ADA to the dwelling units. Okay? You need to apply the Fair Housing Act. And the Fair Housing Act says that an assistance animal does not necessarily just have to be a dog. It could be a cat or a ferret or some other type of animal. And the animal doesn't necessarily have to be trained or certified. Okay? Lastly, on this slide, it's important to note that assistance animals are not pets. So housing providers cannot apply pet rules to assistance animals, cannot apply a pet deposit, for example, or any other fee because of the assistance animal. No matter how you couch it, if the person has to pay money because of the assistance animal, that would not be provided. You also cannot apply the weight, size, or breed restrictions that you might apply to pets. Okay? Again, assistance animals are not considered pets. They are considered assistance animals. So the pet rules should not be applied. Under the Fair Housing Act, the Office of Fair Housing has interpreted that housing providers can impose rules on assistance animals that relate to the health and safety of tenants and property, but it must be based on specific assessment of the animal in question, not based on broad stereotypes and assumptions. So a housing provider can ask that the animal not be biting or jumping at people. The housing provider can ask that the animal's waste be picked up. Okay, so this is a snapshot of the types of health and safety rules that a housing provider can implement, but again, cannot deny a breed based on an assumption or stereotype. It must be based on the specific assessment of the tenant or the animal in question. Last but not least, even though a housing provider cannot charge a pet deposit for the assistance animal, they can recover any damage costs by the animal or by any member of the household. So if any member of the household, two-legged or four-legged, causes damage, the housing provider can use whatever damage deposit or security deposit that they charge all tenants. They can use that to recover any damage caused. Okay? So no pet deposit, but a housing provider can still charge a damage or security deposit that they charge all the other tenants. Okay? And they can recover for any damage caused by any member of the household, two-legged or four-legged. All right? So that gives us an idea of assistance animals as a type of reasonable accommodation. Okay, so let's talk now about what a housing provider can ask for if that housing provider is approached with a reasonable accommodation request. Well, if the person's disability is not obvious, or if the person's need for the accommodation is not obvious as tied to the disability, then a housing provider may ask for verification that the person is disabled and that because of their disability, they need the accommodation in question. Now, some things to note on this slide. The verification should not be limited to just from a doctor. A housing provider should not require that it only come from a doctor. Fair Housing's interpretation of the law says that this verification can come from other persons, such as a medical professional or a peer support group, or a non-medical service agency, or some reliable third party who's in a position to know about the individual's disability. So, medical professional, right? Could be a nurse or a physician's assistant, for example. Peer support group. If someone is an alcoholic, that is considered a disability. Perhaps they go to AA as a peer support group. The leader of the peer support group might be in a position to verify that this person has this disability. A reliable third party who's in a position to know about the individual's disability could be a caregiver. They're not a professional caregiver, but they still provide 24/7 caregiving services. They're in a position to know what that person's disability is and what their needs are. When we talk about a non-medical service agency, maybe a chore worker, somebody who comes and helps that individual do the cleaning and the hygienic issues in the home. So you can see that there are a variety of individuals that could be in a position to verify a person's disability and their reasonable accommodation needs. So housing providers are cautioned not to limit the verification to just a doctor. You must be flexible and open to accepting verification from other individuals in a position to provide the necessary information. Other questions that housing providers can ask just generally of all tenants is whether or not they have the ability to pay the rent. Do they have rental references? Will you comply with the rules? Okay, these are all allowable questions as long as they're applied equally to everyone without regard to a protected class status. But when it comes to dealing with individuals with disabilities, you must stay away from asking privacy questions regarding that person's disabilities, such as the nature and severity of it, if they take any medications, or if you ask to see their medical records, or you ask to talk to their doctor. None of that information is necessary for purposes of verifying reasonable accommodations and should otherwise not be necessary to qualify a person to live in a property. So these are questions that a landlord cannot ask, should avoid, not only to avoid violating privacy laws, but also to avoid violating the Fair Housing Act. Okay. So when must a reasonable accommodation request be granted? A housing provider would grant a reasonable accommodation when they have verification or knowledge that the person is disabled and that because of their disability, they need the accommodation in question and that the request is reasonable. So what does reasonable mean? As promised, here are the two criteria defined under reasonableness, and these are the only two criteria that a housing provider can consider when acknowledging and analyzing a reasonable accommodation request. The first criteria is whether or not the request will impose a financial and administrative burden. Will the request impose a large financial or administrative impact? So the housing provider needs to take into consideration the cost, not just in dollars and cents, but also in administrative resources that may be expended in providing the accommodation request. So for example, if a housing provider was asked to replace a $70,000 elevator, that would be way too costly. In likelihood, the smaller housing providers would be unable to afford that, and that would be a financial burden that could not be met. Okay? Just a very simple example, but just to give you an idea of what you need to take into consideration is what is the financial burden and what is the administrative burden. What resources in dollars and cents would I have to expend to provide this accommodation, and how is it going to impact my individual budget? Those are the questions you have to ask. And what would that take away from my day-to-day operation? The next question is whether or not it provides a fundamental alteration to your business. Are you being asked to do something that is outside of your normal day-to-day business activities? So for example, if you are strictly a housing provider and the tenant asks that your manager distribute medications or provide caregiver services, for a lot of housing providers, that will be a fundamental alteration because they're in the business of providing housing, not in the business of providing supportive services. So that would be outside of their normal business operations. Now, hopefully, you gather from my discussion here that this is going to be very much an individual assessment, housing provider to housing provider, request to request, because only the housing provider in question can determine what finances it has and administrative resources it has to provide the request. And only the individual housing authority or individual housing provider can make the assessment of whether or not what they're being asked to do is within their normal business operations. And each request that comes from an individual with a disability is going to be different from individual to individual. You put those variances together and you have a very individual process. And that's why I said in the beginning that what I hope to do is to provide you the tools to analyze various situations you might encounter as a housing provider, or that you might be expected to address if you are a consumer or an advocate for a consumer. And you can see in these slides how it does vary and how it is a case-by-case scenario. So that is why we can't give you a definitive answer that's a violation, because it varies from situation to situation. But what doesn't vary are the tools you have to analyze. And that's what I want you to pull away most anything from this piece of the presentation, are the tools to analyze reasonable accommodation requests. So what do you do next? Well, first and foremost, when you are presented with an accommodation request, make sure you acknowledge it and do not ignore it, and make sure you communicate with the tenant. We've gotten several complaints from tenants who say the landlord never talked to them, so they thought their request had been denied. We've had other situations where the landlord took so long that the delay began to equal denial. So make sure that you acknowledge receipt of the request and acknowledge that you're working on it, and make sure that you act on it in a timely manner with the individual in question. So if you analyze the request based on the 2 criteria for reasonableness and you determine that it is reasonable, then you provide the accommodation or modification in question. If you've determined based on the 2 criteria for reasonableness that it is in fact not a reasonable request, you must enter into an interactive dialogue with the disabled individual to determine if there is an alternate accommodation that you can implement. The only way you're going to know if there is an alternate accommodation that is satisfactory would be to ask the tenant themselves. So you let them know, I'm sorry, we can't provide your original request because it's too costly or it's outside what we do of our normal business. But what can we do alternatively? So like in the example of the elevator situation, okay, we can't afford to repair it so that it works. I understand that you're on the 2nd floor individual with a disability. How about instead of us fixing the elevator, we move you at our cost to a 1st floor apartment? There's an alternate accommodation. You dialogue with the disabled individual to find out if that will meet their needs. Okay? Interactive dialogue with the disabled individual is critical to this process. All right? All right. I'm just going to pause for a moment here. All right. So our next section here is going to fall under the sex or gender provisions of the Fair Housing Act. And the first discussion we're going to have is on domestic violence situations. And we're going to talk about how certain situations in domestic violence fall under fair housing law and how they might be considered illegal discrimination. There are 3 ways that we can see illegal discrimination under the Fair Housing Act. And I apologize, I'm looking at my fingers here. We've got 3 fingers up. 3 ways that we could see discrimination under the Fair Housing Act in domestic violence situations. The first is discriminatory policies. Your policies that explicitly are going to treat women differently than men. I mean, that's straightforward difference in treatment based on gender. I think we all can see how that would be considered illegal discrimination under the Fair Housing Act. Then we have unequal treatment, which is similar but slightly different, in which we see various scenarios where a housing provider may treat a domestic violence victim differently than he or she would treat victims of other crimes, where they would treat that domestic violence victim more poorly than they do victims of other crimes. Or they apply a policy to evict households for criminal activity only against the women, but not against the men. Or you could have a housing provider that has a policy not to evict victims of domestic violence. Okay? But they forget that even though women are overwhelmingly more likely to be the victims of domestic violence, men can be as well. So if you have a policy of not evicting domestic violence victims, that is great. Just make sure that you apply it equally without regard to gender. Okay? The third way, though, that we see this issue more commonly and more currently is this discriminatory effect or disparate impact. And if you think back to the beginning of our presentation, I talked about the 3 illegal ways of discriminating under the Fair Housing Act. The third way was discriminatory effect. Well, now here's our first issue in which we're going to discuss how the discriminatory effect theory of discrimination applies. Okay? When we are looking at whether or not a particular situation has a discriminatory effect, we first have to look at the policy. And from there, then, we look at the statistical impact. And together, that will give us a view of whether or not we have illegal housing discrimination under the Fair Housing Act. So in this case, we're talking about a policy that many housing providers have, 0 tolerance to crime. Well, what happens when you apply that in domestic violence situations? Well, to answer that, we have to look at the statistics. And there are a lot of numbers on your screen here before you, but basically what it's telling you is that women and minorities are overwhelmingly, statistically, more likely to be the victims of domestic violence. So when you look at the gender issues and you look at the race issue and you look at the national origin issue implicated by these statistics, it leads you to the potential to have a discriminatory effect. When a negative action is taken against victims of domestic violence, such as refusing them housing or evicting them from housing, that could have a larger negative effect on women and certain minorities based on the statistical knowledge we have, thereby having a disparate impact, or otherwise known as discriminatory effect, on gender, race, and national origin. So that three-tier analysis of looking at the policy, the statistics, and the end result helps us understand when we have a discriminatory effect that could be illegal under the Fair Housing Act. So the last element in this analysis is whether or not there is an alternate way to address these scenarios that doesn't necessarily discriminate based on gender or other protected classes. And one solution may be to adopt a policy of not evicting qualified domestic violence victims. And I say qualified by way of saying that, yes, the individual still needs to be able to pay the rent to live there, but you're just not arbitrarily evicting all members of the household, including the domestic violence victim. You're giving them the opportunity to stay. Okay? This analysis and this outcome, you're going to see several times in a few minutes when we talk about some other fair housing issues. So try to keep this analysis in mind when we get to some other issues as well. The next gender discrimination issue that we could encounter involves members of the LGBT community, and it involves sexual orientation and gender identity. Okay? Now, go back in your mind and think about the protected class slide, one of the first slides that we went through in the beginning. And you'll recall that sexual orientation and gender identity are not specific protected classes covered under the Fair Housing Act. However, there are some scenarios that could occur that could imply fair housing issues. One of the first ones involves disability, and this in fact is one of the first scenarios I encountered when I started in fair housing more than 20 years ago, where a housing provider evicted a gay man because he believed that individual had HIV/AIDS. So there were so many things wrong with this scenario. First is that the housing provider made a broad assumption that all gay men must have HIV-positive status or full-blown AIDS. And at that time, he assumed that it was highly contagious and would be a danger to other tenants. And in this scenario, he evicted this individual. How does that imply or implicate the Fair Housing Act? Well, if you remember the definition of disability, the third bullet under that definition was being perceived as having a disability. If a landlord thinks that you have a disability and takes a negative action against you, that would be illegal disability discrimination. And that's what we have in this scenario. The landlord thinks this individual has a disability, which HIV-positive status or full-blown AIDS would be considered a disability under the Fair Housing Act. So the housing authority, the housing provider thinks this individual has a disability and evicts that individual because of that perception. That would be considered illegal disability discrimination under the Fair Housing Act. Another scenario that a person of the LGBT community might encounter involves nonconformity with gender stereotypes. If a property manager refuses to rent an apartment to a prospective tenant because that person is transgender, that may be illegal sex discrimination if the denial is because that tenant does not conform with gender stereotypes. So the Office of Fair Housing has interpreted this scenario as being sex discrimination when the denial is based on non-conformity with gender stereotypes. It's not just for persons who are transgender. It could be any person that a housing provider thinks does not conform with gender stereotypes. So, for example, if a housing provider thinks that all women should wear skirts and a blouse, and you have a woman come dressed in male cargo pants and a male shirt and dressed in the stereotypical masculine way, and the housing provider refuses to rent to that woman because the housing provider doesn't think she conforms with the stereotypes of the way women should dress, then that may be illegal sex discrimination under the Fair Housing Act. So these are two scenarios in which experiences of the LGBT community may still rise to the level of Fair Housing Act discrimination under the disability and the sex provisions. Now, changes to the Fair Housing Act would have to be a congressional act. So HUD has tried to address sexual orientation discrimination specifically in its programs, and that was done by way of a rule that was passed almost 6 years ago. I'm going to shorten the title here and call it the Equal Access Rule. I'm not going to spend a lot of time talking about it because the focus of our discussion is the Fair Housing Act. But I would be neglectful if I did not at least mention, for those of you that are watching who administer HUD programs or administer HUD properties, it's important for you to be aware of this equal access rule that makes it against HUD rules to discriminate against the beneficiaries of HUD programs based on sexual orientation and gender identity. And this rule does that in a variety of ways, beginning by defining these terms, clarifying that family can also mean households where they are same-sex couples. It also makes clear this equal access provision and makes it against the rules to inquire about sexual orientation and gender identity. And lastly, this rule also makes it where the FHA lending program cannot deny a loan simply because of a person's sexual orientation or gender identity. So for those of you, again, that administer HUD programs or administer HUD properties, please be aware of the Equal Access Rule. Go to the HUD.gov/Fair Housing website to find more information about this Equal Access Rule. All right. So next up, we're going to talk about family status. Okay? And like disability, family status actually has a definition, and that's where we will begin. Then we will be talking about some of the do's and the don'ts when dealing with rules and incorporating children in those rules. Then we will talk about occupancy, and then lastly, under family status, we will talk about the Housing for Older Persons Act, which we refer to as HOPA. So first and foremost, what are we talking about when we talk about family status? The simplest way to think of it is the presence of children under the age of 18, okay? The presence of children in the household. It does not mean that a parent has to be present in the household. It could be the biological parent, but it also could be a step-parent. It could also be a foster. It could be guardianship. It could be adoption. It's just the presence of children under the age of 18. Also could be a household that's expecting a child under the age of 18, either through pregnancy or they're going to be assigned guardianship or custodial guardianship of the child, or they're going to be adopting a child. So presence of children under the age of 18 is what we mean when we refer to familial status. So here are some do's and don'ts when you think about your rules and your practices as it involves families with kids. First and foremost, you cannot refuse to rent to qualified families with children simply because they have kids, unless you are a Housing for Older Persons community. And in a couple slides, we're going to define what that is. If you are not senior housing as defined for the Housing for Older Persons Act, then you cannot deny families with children who are otherwise qualified. You want to make sure you do not refuse to rent to qualified families with kids simply because of safety hazards. We've actually had complaints regarding that where the housing provider had safety concerns about the location of a unit or a location of a building. And frankly, if an area is unsafe for children, it likely is unsafe for adults. So from a business standpoint, make the environment safe for everyone and ensure that you are not treating families with children differently than others simply because you're projecting what you think is safe or not safe. The bottom line is that the parents are the ultimate deciders of what's safe or not safe for their family. Housing providers are in the business of providing housing, not parenting families. Okay? I hate to be harsh about it, but I need to drive home the point that it's up to the families to decide what is safe for their children. And as a different side note, but equally important, if there are areas on your property that are unsafe and they're within your control to fix, then fix them. Make it safe for everyone. Because again, if it's unsafe for kids, it's likely unsafe for adults as well. Similarly, do not limit families with children to certain areas of the complex or certain floors. You need to ensure that you are providing equal opportunity to any of your available units to qualified families with children. You cannot segregate them. Just as you would not segregate persons based on race, you cannot segregate based on family status. You must ensure that you integrate families with children throughout the community, the complex, the apartment building itself. Bottom line, if a family with children is qualified, they should have equal access, equal opportunity to rent whatever vacant units you have available. Don't establish rules that specifically target children. Look at your rules and say, do they only say kids? Kids can't do this, kids can't do that. If it does, you need to remove that language and make sure that your rules cover everyone. And again, it's good business sense, not just good fair housing sense. You know, children aren't the only one who leave toys around on the sidewalks proposing or creating tripping hazards. Okay, adults can do the same. You know, you could have 20-year-old, 30-year-old, 40-year-olds playing with their bicycles, their scooters, their basketballs, and leave them on the sidewalk and create this tripping hazard. And if your rules don't specifically say everyone, you know, now your adults can get away with things that kids can't. So that's the business sense of it, right? You want to make sure that everyone is creating a safe environment, not leaving their toys and everything else around. From the fair housing standpoint, you don't want to just single out children. So bottom line, again, do not set rules that just target children. Make sure your rules say everyone. So all occupants, for example, is a term that you could use. If you have recreational facilities such as a pool, or you have a spa equipment or a weight room, you can establish standards based on whatever the industry establishes is safe to use that equipment. Or similarly, if you have a city, for example, that says if you have a private pool that doesn't have a lifeguard, you must ensure that any children under the age of 14 must have an adult present, or something like that, right? So you can comply with any city ordinances and any industry standards regarding the age use of the equipment and facilities. But when you establish the rules, I highly recommend that you cite the city ordinance or you cite the industry standard you are following so that everyone is aware that these aren't arbitrary rules to discriminate against families with kids. These are standards set by the industry or by the city. Okay? So those are some do's and don'ts to adhere to when it comes to rules and children. Okay. Another family status issue that we've encountered is occupancy. Okay. And under some circumstances, a housing provider's overly restrictive occupancy policy could have a discriminatory effect on families with children. There's that term again, okay, discriminatory effect. And the statistics show that your larger households are going to be those with children. So if landlord's policy, occupancy policy, is overly restrictive, it's likely going to have a greater negative impact on families with kids, and thereby could be considered illegal discrimination under the Fair Housing Act. So in response to this, many, many years ago, HUD established occupancy guidelines. We refer to it as the Keating Memo because a gentleman named Frank Keating in our Office of General Counsel was the author of this memo. The author of this memo. Essentially, what this memo says is that 2 persons per bedroom as a general rule is okay. However, in big capital letters, you cannot stop there when determining reasonableness. You can't just take into consideration number of persons per bedroom because there are other factors that could affect how many people can live in a unit. First and foremost, if you had a 2,000 square foot 2-bedroom unit and a 1,000 square foot 2-bedroom unit, I think we all could argue that the 2,000 square foot 2-bedroom unit could hold more people than the 1,000 square foot 2-bedroom unit. Even though they both have the same number of bedrooms, you have the size of the unit as a whole that could perhaps allow additional individuals reasonably in that unit. So the Keating Memo says you need to take into consideration the size of the bedrooms in the units and the configuration of the units themselves. Are there other bedrooms or other rooms that could be livable space, whether it's a dining room area or living room space or even a den? Those all might be considered livable space. And some of that may be determined by your state or local law. So you need to take that into consideration. The state and local laws may also dictate the age of the children at which point you start counting them as occupants. So that's why we have listed here age of children should be taken into consideration. Oftentimes, infants under the age of 1, under the age of 6 months may not be counted in the equation. Maybe, maybe not. Take a look at the state or local laws where you are. The other element to consider is the physical limitations of the housing. Perhaps the housing community is not set to the public sewer and it runs solely on a septic, or it's not set to the public water system and it's running on a well system. And those things then create particular limitations of the number of individuals that can live in the property. Okay. Whatever these elements are, you need to take a thoughtful consideration about these pieces and make sure you document your analysis and the basis for your occupancy policy. Whether it's the state law or the local law that you draw from, maybe print that out and have that as part of your policy and keep that in your documents. But whatever you do, document the decision, the information that informs your decision. Okay? All right, moving on now to the Housing for Older Persons Act, the last piece here in talking about family status. As I mentioned, you cannot refuse to rent to qualified families with children simply because they have kids. The only exception to that is if the property in question is in fact senior housing, as defined by the Housing for Older Persons Act. Under the Housing for Older Persons Act, which is a part of the Fair Housing Law, there are one of 3 ways that your property can be considered senior housing and therefore exempt from the family status provisions. Now, first of all, let me just qualify this, that if you are senior housing as defined on the screen and the screens to come, you are exempt from the family status provisions of the Fair Housing Act, but you are not exempt from the other protected classes. You still must act in accordance with the Fair Housing Law as it pertains to the other protected classes. So you cannot discriminate based on race or color or national origin or religion or disability or gender protected classes. Okay? So that being said, let's talk about the 3 elements of being Housing for Older Persons Act. And it's one or the other. You do not have to meet all 3 criteria. So the first criteria you can meet is if you are federally funded housing for the elderly or the elderly and disabled. So oftentimes HUD properties will be housing for the disabled and for seniors collectively, or will be housing just for seniors. The federal agency, HUD, has designated this as senior housing, even if it's senior and disabled housing. So in that scenario, that property is considered housing for older persons and therefore exempt from the family status provisions of the Fair Housing Act. For everyone else who isn't federally funded, there are two other ways you could be considered senior housing. You could be 62 plus housing, or you can be 55 plus housing. The first is 62 plus housing. In order to be 62 plus housing, it's very simple. All occupants in the property must be 62 years or older, and that is the intention, and that, again, all occupants are 62 years or older. Okay. The third criteria that could make you housing for older persons is 55 plus housing. Now there's three elements to 55 plus housing that must be met in order to meet this particular criteria. At least 80% of the occupied units must be occupied by someone who's 55 years or older. And there must be an intent to operate as 55 plus. So you hold yourself out, you hold your property out as 55 plus housing, where your lease says we are 55 plus housing. Your advertisement says senior or 55 plus housing. All of these things show to us that you do intend to be senior housing, okay? And you have a process to verify the age of the occupants. For example, upon move-in, you ask to see their driver's license, and you are verifying that at least one member of the household who will be occupying the unit is at least 55 years or older. And then you do a similar process on a yearly basis. Perhaps you do a survey of all occupied units to make sure at least one person is still 55 or older living in the unit, so that you maintain the 80%. So you meet all three of these elements and you would be considered 55 plus housing, therefore exempt from the family status provisions of the Fair Housing Act. Okay? So again, the Housing for Older Persons Act says there are three types of properties that could be considered senior housing. Okay? You're one or the other. You do not have to meet all three. The first one is you are federally funded housing for the seniors. The second one, you could be 62 plus housing, or the third, you be 55 plus housing. You meet one of the three as senior housing, you are exempt from the family status provisions of the Fair Housing Act. Okay. All right. Last issue here that we're going to address in this portion is advertising. Okay, a lot of words up here, but basically you have to be careful what you say. Whether verbally or in writing or online or even just a Post-it note, you cannot state a preference, limitation, or otherwise discriminate based on a particular protected class when you are advertising for housing. Okay, and it can come in a variety of ways. As I mentioned, it could be a Post-it note that you place on the local bulletin board. It could be flyers. It could be brochures. It could be the traditional advertising in newspapers, or nowadays online, right? Or on the radio or on TV or even in magazines. It could be in the vacancy sign that you put in the window. Or again, local laundromats, college hubs, grocery store bulletin boards where you post that Post-it note saying you're looking for someone to rent an apartment or something like that. Okay? So you have to be cognizant of when you say things either verbally or in writing, in whatever fashion it may be. If you are seeking to rent your housing or sell your housing, you must be careful in what you say. Now, there is some great guidance. You'll see at the bottom of the screen on this slide. All of the information in the next two slides come from this guidance. It has some great information based on each protected class, words and phrases that you want to avoid, and words and phrases that would be considered common real estate terms that a reasonable person would not find to be discriminatory. So for example, on our slide right now are what are considered common phrases that would be considered acceptable under the Fair Housing Act per the guidance below. You could say master bedroom, desirable neighborhood, kosher meals available, mother-in-law suite, no smoking, family room, right? These are services you provide, or these are types of common real estate related terms. You notice I passed over one, female roommate wanted, because I wanted to save the best for last on this slide. I think we all can agree it clearly states a preference based on gender. So why is that okay? It's in this okay slide, right? The reason is that when you had shared living situations, the housing provider can state a preference based on gender when and only when it's shared living. So the advertisement must make it clear that it's shared living, so like roommate wanted, and the only protected class of which you can state a preference is gender. All the other protected classes are off limits. So this statement, female roommate wanted, meets the criteria. It clearly states shared living and clearly states gender. No other protected classes involved. That's why it's okay. Some phrases to avoid: white family home, adult community, Roselawn Catholic home. When the name of your facility incorporates the name of a religion, you must include an anti-discrimination or a non-discrimination statement afterwards, so that anyone reading that knows that this community or this apartment complex isn't restricted just to people who are Catholic. That would be religious discrimination. So ensure that you use a non-discrimination statement. Okay. So these are just some examples pulled from that guidance that is linked on the previous slide. I would encourage you, if this is an area that you're involved in, to take a look at that information. What about the last piece here? Mr. Chuck, the bulldog, wants to know if you can advertise no pets. And the answer is yes. Okay, you have the right to decide if you're going to have pets or not on your property. But it is important to know that you have to make an exception to that when it comes to assistance animals. So make sure whoever is receiving phone calls and walk-in inquiries, that that person is knowledgeable about the fair housing law and knows about reasonable accommodations and making exceptions for assistance animals. Okay? Just a piece of advice: describe the property, not the tenants that you're seeking. Okay. All right. So overall, this has been a presentation on the basics of the Fair Housing Act. I hope that you have pulled some valuable information. If you have any questions about what you've learned today and or about a particular scenario you may be encountering, please feel free to contact your local fair housing office. On the screen before you are the toll-free numbers for the 10 FHEO, or Fair Housing Equal Opportunity offices throughout the nation, depending on the state where you live. So please, don't hesitate to call us. We'd rather stop discrimination before it even begins. So we want to work in partnership with you to ensure that all of us have equal access and equal opportunity to housing. Thank you for joining me today. Take care. Bye-bye.